We're studying Article 3 of the Constitution. That's the part of the Constitution that governs judicial power. There are several different topics under Article 3 that you're going to want to understand thoroughly to be prepared to take an exam and also to be prepared to practice. The first is judicial review. We are talking about the scope of federal judicial power, and one cannot understand that without understanding the power of judicial review. Judicial review is the power of any federal judge. That's what you really need to understand. Any federal judge. To strike down an act of Congress, to strike down an act of the President, or to strike down the act of some state actor that's a party to a lawsuit. The power of judicial review also involves the power of a federal court to issue an order and judgment and to have that order and judgment obeyed by some other governmental actor. In other words, an order and judgment issued by a federal court, any federal court, be it a U.S. District Court, a U.S. Circuit Court, or obviously the U.S. Supreme Court, is not optional. It must be obeyed, and it must be obeyed to the letter by whatever governmental actor is on the wrong side of the judgment. This is closely related to the idea in your reading about advisory opinions. Federal courts are not allowed to issue advisory opinions. In other words, they're not there to give advice. They're not there, as I put it, to whistle into the wind. There's a more crass way of putting that, but we'll stick with that allusion. They are there to be heard, and they are there to be obeyed. There is a famous example of Thomas Jefferson writing a letter to the Supreme Court asking for their legal advice about a long laundry list of questions. And the Supreme Court wrote a letter back and said, we don't think you understand what we are here to do. Federal courts under Article 3 are empowered to hear cases and controversies. Those are two words in Article 3 that are going to come back time and again. So please make sure you have a grip on that. Article 3 only empowers federal courts to hear cases and controversies. They are not there to give advice. They are there to resolve concrete disputes among or between competing parties whose interests are at odds. So, judicial review, the power of any federal court to resolve a case or controversy, to issue a judgment that resolves the dispute, and if necessary, to strike down an act of Congress, of the President, or of any state actor. That is one of the topics that you need to understand under Article 3 of the Constitution to succeed on a law school exam, and obviously it's something you would need to understand to practice law in this country at all. The second issue, the second topic that we cover under Article 3 that needs to be understood is the whole idea of judicial supremacy. And judicial supremacy is not the power of any federal court to resolve a dispute between the parties, or in the case of a circuit court, to bind the lower courts in the circuit. That's the U.S. Court of Appeals. Judicial supremacy is the power of the United States Supreme Court to bind any state actor in the United States, as I've put it before, down to dog catcher. So those are the first two topics that you really need to have a handle on under Article 3. What I'm going to talk about in this video is a third topic, and that is the issue of federal court jurisdiction. And we're not talking here about civil procedure, talking about subject matter jurisdiction or personal jurisdiction. That's not what I'm talking about. I'm talking here about the constitutional issues around jurisdiction. And that involves the relationship between Congress and the federal judiciary. And one of the checks that Congress has on courts is that Congress, under what's called the Regulations and Exceptions Clause, so please know that term as well, is allowed to a certain extent, regulate the jurisdiction of federal courts. Now, you know from Marbury versus Madison that Congress is not allowed to expand the original jurisdiction of the Supreme Court. The Supreme Court only has original jurisdiction in a very limited number of cases, and those generally involve either ambassadors, consuls, or other diplomats. That's one category of case that the Supreme Court can hear on original jurisdiction. The other category of case would be states suing other states over some kind of dispute. Could be territory dispute or anything like that. Otherwise, the Supreme Court has only appellate jurisdiction. And these are words that you need not, it's not just that you need to know the words, as I always say, the syllables in these words and string them together on an answer. These words have to have very concrete meaning in your head when you consider them, and you need to know exactly what they mean. Original jurisdiction means the power of a court to hear a case when the case originates in that court. In other words, there is no lower court that already heard the case. That's original jurisdiction. You want to actually visualize that in your head. When you go back to Marbury versus Madison, what that means would be what Marbury's lawyer got on a horse and went to the Supreme Court clerk's office and filed his application for a writ of mandamus there without filing it first at some lower court. Therefore, Marbury had invoked, or tried to invoke, the original jurisdiction of the U.S. Supreme Court. And we know the Supreme Court doesn't have original jurisdiction. Right? The Supreme Court does not have original jurisdiction to issue writs of mandamus or to entertain applications for mandamus, because it only has original jurisdiction in cases involving ambassadors, consuls, and other diplomats or states suing states. And a run-of-the-mill application for a writ of mandamus does not fit into one of those categories. So Congress cannot mess around with, how's that for a legal term? Congress is not allowed to mess around with the original jurisdiction of the U.S. Supreme Court. However, under the regulations and exceptions clause, or you could say exceptions regulations, don't really care which order you put it in, but under that clause, Congress is allowed to regulate the appellate jurisdiction of the Supreme Court, so you need to know those rules. Congress may not mess around with the original jurisdiction of the Supreme Court. Congress is permitted to regulate the appellate jurisdiction of the U.S. Supreme Court. So, if Congress tells the Supreme Court that it is not allowed to hear a certain class of cases, then the Supreme Court is not allowed to hear that class of cases under its appellate jurisdiction. The leading case in this area is a famous case called Ex Parte McCardle. McCardle was a racist agitator in the South and was arrested for publishing certain materials that were racist and that the government thought might cause agitation. And he was arrested under something called the Reconstruction laws. That's a series of laws passed by Congress after the Civil War to try to patch the country back together, figure out what we're going to do post-Civil War. That series of laws, under the Reconstruction laws, the arrest of McCardle was valid. The question was, in Ex Parte McCardle was whether the arrest was valid under the Constitution, which has in it, of course, a First Amendment, which says that the government is not allowed to punish somebody for their speech, which seems like pretty clearly like what McCardle was arrested for, was for writing, publishing something. Here's the deal. The Supreme Court, when it was considering Ex Parte McCardle in its internal deliberations, and there's been now a lot of written about this case historically, likely concluded that the Reconstruction laws at issue that permitted the arrest of somebody for publishing something did violate the First Amendment of the U.S. Constitution. Furthermore, the Supreme Court, in reviewing the Reconstruction laws, likely concluded that much of the entire framework created under the Reconstruction laws was unconstitutional, because there are parts of the Reconstruction laws that violate the First Amendment. There were arguably parts that would have violated the Fourth Amendment, search and seizure, things like that. So the court was kind of in a jam, because here we are, we're post-Civil War, the Reconstruction laws are at issue in the case, the Reconstruction laws may become issues in other cases, and the Supreme Court is looking at these Reconstruction laws saying we can't square these laws with the Bill of Rights, which clearly restrains Congress, because the Bill of Rights starts with the words, right, Congress shall make no law. So what are we to do about it? There is some speculation, and it's probably accurate, that there might have been some communication, actually, which is something that's never supposed to happen and almost never has happened, with the possible exception of this case. There might have been some underhanded communication going on between people in the judicial branch and people in the legislative branch, in which the people in the judicial branch who were working for the Supreme Court might have told people, maybe staffers, people like that, working for the legislative branch, it's really too bad that we even have jurisdiction to hear a case like this, because, boy, it's going to be really tough for us, the Supreme Court, to say that the Reconstruction laws are unconstitutional. Really was not a good idea for Congress to leave this kind of issue within the purview of the Supreme Court. Boy, if you didn't want to have your laws struck down, it's too bad we have jurisdiction to even hear cases arising under those laws, the Reconstruction laws. The bottom line here is the Supreme Court's in a jam. They don't want to strike down the Reconstruction laws. Striking down the Reconstruction laws could ignite a second civil war. They don't know what to do with this case. They don't want jurisdiction. That's interesting, right? The Supreme Court doesn't want jurisdiction to hear this case. That's important in understanding what happened in this case. What happened in this case is that ultimately, one way or another, Congress got wind that the Supreme Court was of necessity going to have some problems with the Reconstruction laws. The posture of the McCardle case at the time that Congress finally acted was that oral argument had already happened in the case. What does that mean? Here's the way the Supreme Court works. The first step is somebody from a court below, somebody who's lost in a court below, has to apply for certiorari or cert. That is a writ that would be issued by the Supreme Court. The court would issue a writ of certiorari. All that means is that the court has agreed to hear a case about a certain subject, and they've granted leave, if you will, to appeal to the U.S. Supreme Court. Incidentally, it only takes 4 justices to vote to grant cert. It doesn't take a majority on the court. 4 out of the 9 would have to agree before the Supreme Court would issue a writ of certiorari. Now, after that happens, the case gets what lawyers call worked up. All kinds of orders are issued about scheduling, the due dates for briefs, all that good stuff. And what happens is that the clerks for the justices begin their process of researching the issues in the case. The justices themselves obviously get involved in looking at the issues in the case. Having worked in an appellate court myself, not the Supreme Court, but in an appellate court myself, I can tell you, in an appellate court, a whole lot of research and a whole lot of legwork is being done long before a case is set for oral argument. Lawyers seem to think, any lawyer who hasn't really had experience in an appellate court, doesn't know the inner workings of an appellate court, lawyers tend to assume that oral argument means something, and I don't mean to sound cynical here, but oral argument in a case does not mean very much. Lawyers say, well, I think I'll have my chance to make my case at oral argument, I'll get my chance to win at oral argument. If you've waited till oral argument to make your best case, you've already lost. Oral argument is not your chance to win a case. Oral argument is your chance to change the judges' minds, because by the time oral argument is scheduled, those judges have made up their minds, I can tell you. There's no question about it. They've made up their minds. They'll be peppering you with questions, trying to probe for weaknesses in your argument, but at that point, you need to know what you're doing at oral argument. You need to know that you're trying to change minds, you're not trying to get them made up. Now, oral argument then is scheduled, and you can listen to those. Maybe we will listen to some of those throughout the term. Oral argument is scheduled. As soon as oral argument is done, sometimes the same day, sometimes not, but soon after oral argument, the judges meet in a conference, and they decide the case. They vote. So after oral argument, you have a matter of hours, days at the most, before there's an actual vote of the justices on the Supreme Court how to dispose of the case. At that point, if the Chief Justice, this is one of the perks of being the Chief Justice, if the Chief Justice is in the majority, then the Chief Justice decides who writes the opinion. So the Chief Justice assigns the opinion to an author. You've noticed in these cases that there's an author for each opinion. If the Chief Justice is not in the majority, then the ranking member, the senior member who is in the majority, would assign who writes the opinion. They try to obviously divide up the labor between the 9 justices, among the 9 justices, in a fairly even way. Now, the reason I say all this is, again, I want you to understand the posture of the case. The McCardle case, at the time that Congress finally acted, was post-oral argument. And what that means was the case cert had been granted, the parties had written their briefs, submitted their arguments, the case had been thoroughly worked up, thoroughly researched, decisions had been made, a vote, in all likelihood, had already been taken by the justices. So the question is, at that point, is it too late? Right, I hope you got this out of McCardle. At that point, is it too late for Congress to take away the Supreme Court's appellate jurisdiction to hear a class of cases?